Hello everyone and welcome to our Lunch and Learn today. My name is Tara Daly. I am the Managing Director at MSS, the HR People. And today our Lunch and Learn is on the best handling of probation periods. Our Lunch and Learn, the session will be recorded today, so you'll be provided with a link afterwards. So you can take some notes, but we will also provide you the link so you'll be able to look at it again. If you have any questions, feel free to pop them into our Q&A section, which is activated there, or pop them into the chat section also. The session should last around 20 minutes, and after that, there's time to pop some additional questions in there, should you have any. So I hope you find it beneficial, and we will get started. Okay, so I suppose probation periods, just to note, are extremely important, and they're probably one of the most underutilized areas of the employment process by employers at times. And oftentimes we will receive a query from a client at the last minute saying, oh, they've gone past the probation, what can I do? The person's not the right fit. And unfortunately, when you do that, things get a little bit more complicated and it makes it a bit more challenging. And so we're always kind of raging when we get those queries because it could easily have been handled better and dealt with at an earlier stage. So today is all about learning how to handle the probation period in the best practice way possible. At the end of today's session, I'm hoping that you'll understand why the probation period is important in the first place. You'll understand the implications of not doing it properly. And you'll also have some practical tips to take away with you when it comes to making that probation a success. What is a probation period, first and foremost? Essentially, the probation period is a trial period, isn't it? So, but it's not just for the employer, it's for both. So it can be used by both the employee to decide, is this actually the right fit for them, but also for the employer to determine if they're the right fit for the role. So the probationary period is an essential trial period for assessing that suitability from both sides of the relationship. What are we trying to achieve? There's a couple of things in the probationary period that we want to do. The purpose of it is to, over the first few months, to shape the individual's long-term performance. Okay, to do that, we want to evaluate if the employee is a good fit for the role, but also for the company and what the company are all about, the company's culture, to see if the employee's role aligns with their career goals and their expectations. So is this really aligned with what they're looking for? To give the employee a chance to improve their performance and to support the employee. Essentially, what we want is for that employee to be the right fit and to be successful in their probationary period. So we want to put the support mechanisms in place, the training in place that actually facilitates them and gives them the best chance at success in that probation period. And when we've done that, we can comfortably say, no, do you know what? We've done everything we can and they're just not the right fit, it just hasn't worked out. So really the purpose of it is to evaluate, to align it with their expectations, to give the employee the chance to improve and also to support them. But ultimately what we're trying to do is to determine, are they actually suitable for the role and for the company? It's important to ask a couple of questions when considering, are you managing the probation period correctly? And I would suggest that you maybe take a couple of minutes just to think about your answers to these questions, or even if you want to pop them in the chat function there, you can as well. The first question is, do you have a probation clause or policy? And again, I welcome anybody to pop into the chat any answers, yes or no, so that we can get some insights. So do you have a probation clause or policy outlined within your contract, within your handbooks, within your policies? So we've got one saying yes. Okay, yep, in the handbook, another yes, okay. So far so good. A lot of you have your probation clause in your policy, or probation clause somewhere, either in your handbook or in your terms and conditions. The other question then is, we've got a no there as well from somebody, so interesting there. Another question is, do employees always receive feedback during the probation period? So maybe have a think about, is that the case in your organizations? Do employees receive feedback during the probation period? And if you could pop your answers into the chat there again. Okay, we've got one no. So one organization that they don't receive feedback. We've got another no there. Okay, quite interesting. Not every time, so maybe occasionally for some organizations. Sometimes if we have the time, they should. It doesn't always happen. Okay, and I think that one is probably the most common answer that we get. They should, but it doesn't always happen because we're always so rushed and we don't often have the time to do it. Okay, moving on. Do you always ensure employees don't go beyond the probation period if they are not suitable? So let's have a think about what your answer is there. Is there ever a time when they go beyond the probation period and we are outside of that timeline? Okay, so yes, it happens in some organizations. Yes, it has happened in the past. Very good. Okay. Okay, sometimes they slip through. Again, quite a common one for us that, we're so busy that sometimes they slip through and we haven't monitored their performance. And moving on then, do you follow any process when terminating the employment during the probation? So quite an important question there. Is it still the case that we can just terminate? Do you actually follow a process when you're terminating someone's employment? So, or do you simply just let them go? Is it as straightforward as that for your company? Okay. No feedback just yet there. So we will move on. Okay, somebody's saying, no, not really, just a conversation, never happened. We usually have a meeting and explain why we are letting them go. Okay, good. All right. So some important answers there and reflection for you when considering, are you successfully managing the probation period? The other one is, do you seek feedback from employees leaving during the probation period? That's also another important aspect of it. So I'd suggest that you go away and you reflect on those areas to see, is there any tweaks that you need to make there to make the process more successful? Why is probation management important? Because there are consequences if we don't do it properly. So there's a couple of areas that it can impact if we're not properly managing it. The first is it can result in decreased productivity and performance. It can have an impact then on the morale and the motivation of the team. Turnover can then be impacted, people leaving because they're simply not onboarded correctly or they're not getting the support or the training they needed. That then means that you have to re-recruit, and it can cost up to twice your annual salary if you have to keep replacing people. Legal risks and disputes, and we'll have a look at those in a couple of minutes. There can be damage to the organizations where, people have left during the probation period. The employer might think it's very harmless, or they're only in the door, but you forget that those employees go out that workplace with what your organization is about, and they share that with other people then. So it's very important that we get the feedback and that we manage this process for our brand and our reputation as well. Loss of time and resources, so all the time onboarding, training, all of that sort of stuff. If we're not properly managing that probation period, then it's a waste of everyone's time. It's a waste of everyone who recruited them, all the people who interviewed, the people who did the induction. That then starts to be a waste of everyone's time. Employees who are not a good fit for the company. So ultimately, we're left with people who maybe aren't the right fit for the organization. Okay, and this happens all often, and I think it's something that we need to pay a bit more attention to. Okay, so let's have a look at the legislation in Ireland. So probation forms part of the contract of employment usually, and Usually continuing employment is subject to successful completion of probation. So it's helpful to look at kind of the legal position with regards to managing probation periods. And the first question I ask you is, I suppose we've had a bit of reflection on it a moment ago, but is, can you dismiss someone without consequences during the probation? And so I'll put that out to the chat just for a quick question, but can you dismiss somebody without consequences during the probation period? Okay, so somebody's saying yes. Okay. So far we've got someone saying yes, you can dismiss without consequences. So interesting. And we'll have a look back at that now in a second. Somebody saying, I wouldn't think so. All right, so let's have a look at the legislation and get a better picture on it. Here's an overview of the legal framework. So there's a few pieces of legislation that are applicable during that probationary period that we need to be mindful of. The Industrial Relations Act is the first one. An employee who doesn't have a year's service, so effectively an employee who's in their probation period, can make a complaint under this piece of legislation, effectively saying that they were unfairly treated or unfairly let go during this probationary process. And we have seen a number of these claims kind of increasingly over the last while from employees, and the court's taking quite a, I suppose, favourable position towards the employee and giving them kind of even moderate awards just to kind of, you know, recognise any sort of unfair treatment during that process. So an industrial relations claim can be made by an employee. Interesting to note that most industrial relations claims are not legally binding on the employer, so the employer technically does not have to pay the industrial relations claim. However, it is published in most circumstances, and it also is, you know, so therefore there's potential reputational damage there. There's also the damage that it could cause to the culture of the organization. If you had a lot of these cases against your company that were well-founded, it starts to reflect and make other employees start to reflect on the culture of the organization and what type of company it is to work for. So the Industrial Relations Act, employees can take a claim to say that they were unfairly treated during the probation period under this particular act, and that can result in some sort of a recommended award from the courts. The Unfair Dismissals Act generally applies to employees who have over a year's service. However, there are some exceptions to this. If the termination is proven to be on the grounds of any of these reasons here, so these protected characteristics, then they could take a claim under the Unfair Dismissals Act as well. The potential awards under that can be anywhere up to 2 years' salary. So it's important to reflect on those areas: maternity reasons, adoptive reasons, availing of protected leave, parental leave, carers leave, exercising rights under the minimum wage, trade union membership, or apprenticeship. And interestingly, for apprenticeships, the Unfair Dismissals Act applies after 6 months service. They do not need a year's service. So that's an important one to note as well. Particularly on the maternity reasons, I would exercise extreme caution around that, and there must be exceptional circumstances. If you have an employee who's pregnant, if there was any sort of termination to take place there, you need to be extremely cautious around that, as there are high protections around pregnant individuals. We then have safety legislation in Ireland. As we know, the Safety, Health and Welfare at Work Act provides a duty of care, or places a duty of care onto employers to protect, as far as reasonably practicable, the safety of employees' welfare at work. So under this, we have a duty to protect employees during the probation period from bullying, harassment, and any sort of unsafe treatment or risks during that period of time. So that's another area of claim or issue that the employee could potentially take a bring a dispute against your company under the safety legislation in Ireland. We touched briefly on kind of protected characteristics earlier. Equality claims are another one that can happen within those first 6 months within the probationary period. If an employee is dismissed on the basis of protected characteristics, there is potential that they could take a claim under the Equality Acts to claim that they were treated less favourably because they fall into one of these protected characteristics. That might be how they were treated during the probation, that they didn't get fair treatment, or it could be that they were terminated during the probation. So they could take a claim either way to say that they were discriminated against in the way that they were treated or in the way that they were dismissed. And it was because of one of the protective characteristics that they fell under. There are 9 individual protected characteristics in Ireland, and I'll take you through them now. A lot of them you will be familiar with already. The first one is gender, so male, female, non-binary, transgender. Civil status, so whether someone's married, divorced, widowed, civil partnership. Family status, so if they're a parent or they're acting in loco parentis. Sexual orientation, so whether they're heterosexual, bisexual, or homosexual. Religious belief or lack of. Age or, sorry, I was going to let somebody in there. Age, disability, which it's important to note is broadly defined. So that can include both mental disabilities and physical disabilities. Race, so race, colour, nationality, ethnic or national origins, or membership of the travelling community. So an employee who is dismissed because of any of these protected characteristics or treated less favourably because of any of these characteristics can take a discrimination claim under the Equality Acts in Ireland, even during the probationary period. So that's very important to note that risk. So let's have a look then at some of the recent changes that came in. The Transparent and Predictable Working Conditions Regulations 2022 introduced what many of us are aware of are the Day 5 statement. It amended the Day 5 statement, which is a statement of terms that it's a mini statement of terms, essentially, that should be given to an employee within the first 5 days of their employment. And what it added to that was that it should have information in this Day 5 statement related to the duration and the conditions of a probationary period. This was brought in from August 2022. The probation period, it also states, should not exceed 6 months, except in limited exceptional circumstances. Okay, so what are exceptional circumstances? There's no definition around it. However, it could be, and it's also exceptional circumstances where it's in the interest of the employee to do so. Okay, so that's an interesting one. When is it how is it in the interest of the employee to do so? Arguably, it's always in the interest of the employee to extend because you're giving them an extra chance to improve their performance. However, I think if an organisation couldn't show that they were trying to actively manage the probation period before that end date and there were no reviews done and no feedback, that the courts may look less favourably on these exceptional circumstances because you didn't actively try to manage that probation before you extended, and it was an unnecessary extension. What the Act also states is that it shouldn't be extended for more than 12 months. However, we would recommend that you limit the extension to 11 months because obviously, as I mentioned earlier, the Unfair Dismissals Act kicks in after 12 months. So if we are terminating at that 12-month mark, you may be covered under unfair dismissals claims as well. So 11 months we would recommend is the max. Probationary periods generally range from 3 to 6 months. We would often see 3 months for kind of promotion roles, 6 months for new roles within the business. It should be outlined in the full contract and the statement of terms. And we'll have a look at what that clause should include in a couple of moments. Quick summary in terms of the redress and the awards that employees can get under these pieces of legislation. Constructive dismissal could be 2 years' salary. So that's the Unfair Dismissals Act. Equality claims, as I said, up to 2 years' salary, and personal injury claims is another area that could be looked at as well, where somebody claims personal injury because of how they were treated or some sort of health and safety issue during that initial year or initial probation period. So what are the obligations for employers during the probationary period? Clear expectations should be communicated, ongoing support, fair treatment and compliance with the laws. Make sure your documentation reflects the reality of the situation. So I've often seen on client sites where they might do a review and they're trying to keep the employee happy, so they kind of do a nice little fluffy, the employee's great type of review. But then when it comes to the crux of it, we are left with, we want to get rid of this employee, but now we've got these favourable reviews that don't actually reflect the reality of the situation. So make sure that they are accurate, the reviews that we're carrying out. Follow fair procedures. So we are going to look at that in a minute, but really we would recommend that you give fair procedures to each termination notice, information provided, some sort of right to reply or discussion with the employee, and that there's impartiality on that. Adhere to the legal obligations and the statutory rights as well. So obviously people will be entitled to certain minimum notice periods, and your contract will be able to guide you on those. What should the probationary clause look like? It should have a couple of things stipulated in it. So I've seen a lot of probationary clauses which simply outline the length of the probationary period, but they don't include some essentials that we would recommend be in there. The first is the length obviously should be very clear. And obviously we've seen that's now a legal requirement under the transparent and predictable working conditions. The extension in the case of absence. So we should have a clause in there to allow you to extend the probationary period to take into account any periods of leave, whether authorised or unauthorised. That the disciplinary procedure doesn't apply, but also make sure that you flag in there that the performance improvement plan doesn't apply. Whatever procedures don't apply during that process, that you're very clear about it in your terms and conditions. Employment may be terminated at the absolute discretion for any or no reason. It's very important that if you intend to be able to terminate someone for any or no reason, that you have a clause in there to allow for that. And again, there are limited circumstances around that, and we'll discuss that. In the case of misconduct, we should put in there that there will be a procedure applied, and the right to extend the probationary period should be in there for up to 11 months. So we should highlight in there that they can extend it up to 11 months. Okay, so quick look at best practice in probation. So probationary reviews are best practice for legal reasons, because we can show, let's say if we got an industrial relations claim, that actually we did treat them fairly, we did highlight the issues to them throughout that process before we took the decision to dismiss, that we didn't discriminate because here are the genuine performance issues and here's the records of the discussions we had. It also provides a framework for the feedback, so you have clear criteria in there that you can consistently review every new person or every new role on, so that you're not being biased and that you're not being inconsistent in your approach. It shows the employee we're taking it seriously, so giving them a dedicated time to give them feedback and to seek feedback shows we're taking it seriously. And when we don't carry out reviews with staff, we don't keep on top of the probation periods. And so sometimes the deadline can get missed because we're not doing those reviews. It helps to keep us focused. A key aspect, and I find that sometimes we assume all too often that employees know what's expected of them, but don't assume that to be the case. Make sure that you are clear in terms of what your expectations are. Spell it out for them so that they are completely clear as to what exactly you're looking for when it comes to a success in this probation period. Regular reviews we would suggest at 3 and 5 months, and usually a final review for the decision at the end. And when an employee starts, I would suggest that you make a note of that expiry date and also make a note of the 1 year timeline. So what's the date when they're going to be a year with you, so that you can keep a track for any unfair dismissals triggers, but also the date of the expiry of the probation period, and that you put that into your system and have it somewhere that it triggers for you and you remember it. Make sure you start your reviews on time so that it shows people you're taking it seriously, and complete on the date scheduled. A couple of examples here. Katie's in her 5th month working as a catering assistant in a restaurant. She has been late numerous times and is not following absence procedures despite being spoken to by her manager. How should we handle it? So I'll let you guys have a little think about it there, and then I will tell you the answer. Okay, so lateness a couple of times and not following the absence procedures, and she's been spoken to about it a couple of times. Essentially what we should do is flag it with her immediately, give her a copy of the absence procedures, and tell her of the consequences if she fails to improve. So she needs to be made aware that the probationary period may not be successful if she doesn't improve, and make a note of the conversation that's had. An employee who's in her probation period raises a complaint during her review that she is being bullied by her colleague. What should you do? Okay. If an employee raises a complaint of this nature, you need to listen to it, show empathy, highlight the internal procedures available to them, be impartial but empathetic. And if they're not saying it's having a direct impact on their performance, so if you're giving them feedback about their performance and they're bringing this issue up separately, then I would treat it separately and tell them, look, I'm sorry to hear that you have some concerns there. We will stick with the probation review for now, and we will discuss that afterwards and make some time afterwards to follow up with them on that. Okay, an employee is 3 weeks outside the probation period, but the company haven't extended it yet, or taken any decision to terminate. However, they are unhappy with her performance and wish to terminate the employment now. What should the company do? So, quick think about that. Okay, so obviously if they're 3 weeks outside the probationary period, they need to now go through the disciplinary process because they are now outside of the exemptions when it comes to the disciplinary procedure, and they need to treat it in accordance with their disciplinary process. Otherwise, they face the risk of industrial relations claims and all of the other claims that we talked about. Performance improvement plans and things like that can be put in place. We talked about the extension of probationary period. So when you're extending, put it in writing. Make sure you do so before the expiry of the probation period. If you're terminating employment during the probation, what we would recommend is some sort of process is followed. So although the disciplinary procedure, as per that clause you're going to put into your contracts, says that the disciplinary process doesn't apply, the courts do look for some sort of fair process or natural justice. So what that looks like and what we recommend is that you, first of all, seek advice from either ourselves or from the HR department. Make sure that you have some sort of fair process of advance notice, that they're allowed to bring someone with them. Keep notes of the meeting. Make sure that you consider what they put forward as their explanation for the underperformance or the misconduct. And if there's misconduct, I would usually provide the opportunity of an appeal as well. So the do's of conducting probationary periods: don't allow things to fester. Sit down with the employee in advance if you have any issues that may need to be addressed. So don't wait for the reviews to get the feedback going. Make sure that that's ongoing as well. I would share the review form with them in advance so that they can prepare. Sometimes I get them to fill out the calculations of the evaluation part as well. And so that allows you in the meeting to go through how did they score themselves, and then to discuss the scores that you've given and to try and come to, well, actually, this is why I've given you this score. And I think these are the areas that need to improve, and get some clarity there on it. The don'ts: so don't extend beyond 11 months. Don't fail to properly communicate. Don't be unapproachable. Don't send employees the probation review form without having a verbal conversation also. So don't just send them your review that's written into the document. Sit down with them and discuss your feedback. Okay, so moving quickly on to evaluation then. What we would recommend is there's some sort of review scoring matrix in there so that you are scoring people, and ultimately you can see whether they're moving towards success or not success. And the employee gets a very tangible picture then. So even if the comments, say, weren't accurate or didn't reflect the reality, the score itself is reflective of where they're at. We would not recommend having a 3-tier system because usually they tend to fall in the middle and everybody comes out with an average or a middle score. Probably a 4-tier system is better. Here's a sample of one. And the type of areas that you want to look at are job knowledge. How well does the employee understand their roles and their responsibilities? Could they have better understanding of any aspects of the job? So you're going to assess their knowledge, and then you give them a score along those lines. You look at the quantity of work. Is the employee consistently completing tasks within their specified timeframes? Does the employee need to manage their time better? Quality of work then is looked at. Is the employee completing their duties to the standard required? Attitude: what is the employee's attitude regarding their work? This is an area we sometimes forget to assess employees on, but it's an important one when it comes to fit. What is that employee's attitude, and does it match with our culture here? And then the rapport with team members and colleagues, again, coming down to that culture aspect. How is the employee settling in? Are we happy with the way in which the employee is getting along with other staff members? Have they been introduced to everyone? Attendance is important as well. I would expect high attendance from anybody who's in their probationary period, because that's usually the time when they should be on their absolute best behaviour. So if there's any attendance issues, it is a red flag. Punctuality, similarly enough, but we should be assessing that, and lateness, and making sure we clarify it's not acceptable. Following instructions, so how helpful are they? Have they been able to follow reasonable instructions? Initiative: are they using their initiative? Do they go out of their way to take on tasks, or do they need to be told to do everything? And obviously you have a section for additional comments there or recommendations in terms of what their feedback is. And two-way feedback is important. So what support do they need? What do they need to make them successful in their opinion? And you make a clear outline then of any recommendations that are required. So this is what your reviews should reflect. It should have a clear assessment on where that employee is at, so that anyone who picks it up would be able to see what the level of performance this employee is at and whether they're nearing success or not. Okay. And then have your final observations, anything like that, you record it down. Just a quick look at misconduct versus performance. So there are two different types of areas, I suppose, when it comes to issues that can arise in the probation period. You've got misconduct, which generally is breaches or behavioural breaches, policy breaches. And then you've performance, which is related to the skills or the productivity. Okay. Addressing misconduct usually requires you to act quickly, obviously, to make sure that it's addressed head on, investigate it and gather evidence and document everything. So again, that prior notice of a meeting, meet with them, allow them to bring someone with them, consider what they say before you make any decision. Provide clear warnings and a chance to improve if appropriate. Obviously, if it's more serious misconduct, then we may be moving towards dismissal and not warnings. Termination for misconduct can be immediate if justified, but I would seek advice from your HR professionals or ourselves for anything like that. Performance then, obviously identify the gaps early, provide support and training to help them improve, monitor that progress. So don't just leave it sit, make sure you follow up with them. And if there's no improvement, make sure that they know that termination can occur. And that can be the case then if you've flagged with them the issues, you may be moving towards termination at the end. But remember, consistency and adherence to the law for any sort of process is important. So whilst you don't have to go through the disciplinary procedure, particularly where misconduct is at play, we would recommend that you follow some sort of fair process where they're given the right to reply and full consideration is given to the facts before we make that decision. And ultimately, what we want to drive home is that you should be doing your reviews and that you have clear records to show that they have been told of the expectations and the improvements necessary. So I'm running a bit behind. So has anybody got any questions? And I appreciate that was a lot of information. Thank you so much for listening, and hopefully you've been able to enjoy your lunch whilst listening. So I'll leave it open to some questions there for anybody who wants to jump in. And just to let you know, we will be running a full training session for the end of March, and that will include a lot more detail in terms of the employment legislation and some of the case law to get into what the courts are now looking at. Okay, so what should I do with an employee on probation who went on long-term sick leave? Okay, so I mean, for that type of situation, I think it's important to write out to the employee and be seen to give them an opportunity to engage, to express your concern for somebody who's out on long-term sick leave. But you should maintain that communication with them during that process so that they don't just get left sitting out there whilst the probation is moving on. When would you recommend doing reviews before the final 6-month review? I would say probably do the 5-month review. I mean, the 5-month review could be your final one, but probably the 5 months is the one just before that. Can I extend the probation several times? Yes, you can, provided that you're still sticking to the kind of maximum limits of 6 months and 11 months in exceptional circumstances. Okay. So some good questions there. Thank you so much. What should I do if an employee says they were treated unfairly after failing their probation? I think if somebody's saying that they were treated unfairly during the probationary process or during their employment, as an employer, you still have a duty of care to your existing employees, and you also, want to make sure that there's nothing there that's potentially a claim coming down the lines. So I would make sure to look at it, investigate it, look at it through your grievance process, or investigate it through your internal procedures to make sure that if there are any actions that are required to make sure it doesn't happen again, that you tackle those. In certain circumstances where somebody, say, resigns, and runs out saying this workplace is intolerable, you might consider giving them an option to reconsider their resignation and flag the internal procedures to them. But that's a good question. Thank you so much. You're very welcome. Okay. I'll just jump into the Q&A section, make sure I haven't missed any in there. No, we're okay. So as I said, you will receive, we'll pop this up and we'll create a link for it. So we'll send it to anybody who just wants to look back on it and refresh their mind as to some of the points that we raised. But thank you so much for your time, and keep an eye out for our probationary training towards the end of March.